Welcome again to live session of Manu Law Classes. I'm Dinesh and I will take today's news analysis. So in today's newspaper, I will discuss the important news. Today is 9th May 2023. So now we come to the important news. So first news is court's order will be discussed with all stakeholders. So basically this news relates to the Constitution of India. And what happened in this news? Honorable Minister or Honorable Home Minister Shri Amit Shah ji on Monday said that the order of Manipur High Courts to grant scheduled tribe status to majority Maitri community in Manipur will be discussed. So now we will discuss this how a particular tribe is declared as scheduled tribe or SC or OBC. What is the procedure of that? So there are four kinds of classes or caste we can say which are found in our country. One is general, second is OBC, and third is SC, and fourth is ST. So now question arises how these classes are determined or were determined at the time of implementation or when the Constitution of India came into force. So जब हमारे देश में कॉन्स्टिट्यूशन लागू हुआ था वहां पर हमने देश की जो कास्ट हैं जो लोग हैं उनको चार ग्रुप में बांटा था. सो उनमें से फर्स्ट ग्रुप होता है जनरल क्लासेस. जनरल क्लासेस आर दोज क्लासेस विच डू नॉट टेक एनी काइंड ऑफ रिजर्वेशन बेनिफिट. ठीक है, लेकिन अभी उन जनरल क्लासेस में को भी दो भागों में डिवाइड कर दिया गया है. एक होता है जनरल अपर क्लासेस और एक होता है जनरल काइंड ऑफ बैकवर्ड और इकोनॉमिकली बैकवर्ड क्लासेस. सो अब इकोनॉमिकली बैकवर्ड क्लासेस को जनरल में से जो है 10% रिजर्वेशन दिया जाता है. सो फॉर दिस पर्पज यू मे रेफर आर्टिकल 15 क्लॉज 6 एंड आर्टिकल 16 क्लॉज 6 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया एंड 103rd कॉन्स्टिट्यूशनल अमेंडमेंट. तो ये आपके लिए इंपॉर्टेंट है. अभी रिसेंटली क्या हुआ है कि मणिपुर हाई कोर्ट ने एक मैत्री कमेटी है कहाँ की है ये मणिपुर की मैत्री कम्युनिटी को एक एसटी का स्टेटस दे दिया गया है. तो ये लोग वहां पर मेजोरिटी में पाए जाते हैं. तो नाउ इस पर थोड़ा सा एक वी कैन से दैट द पॉलिटिकल क्राइसिस आया वहां पर. तो नाउ द स्टेटमेंट ऑफ होम मिनिस्टर श्री अमित शाह जी दैट दिस विल बी डिस्कस्ड. तो नाउ फर्स्ट क्वेश्चन इज दैट whether High Court has the power to declare any community as SC or ST. So primarily if we see the provisions of the Constitution, अगर हम कॉन्स्टिट्यूशन के प्रोविजंस देखते हैं तो कॉन्स्टिट्यूशन में आर्टिकल 340 है. सो आर्टिकल 340 गिव्स पावर टू द प्रेसिडेंट टू डिक्लेयर एनी कम्युनिटी एज SC ST. तो प्रेसिडेंट कैसे इसको डिक्लेयर करते हैं? प्रेसिडेंट सेट अप एन इंक्वायरी कमीशन. पहले प्रेसिडेंट एक इंक्वायरी कमीशन बनाते हैं और वो इंक्वायरी कमीशन जो है इंक्वायरी करता है, इन्वेस्टिगेशन करता है इनटू द अफेयर्स ऑफ दैट पर्टिकुलर कम्युनिटी. कि मान लिया अगर कोई कम्युनिटी आज ये कहती है कि वी शुड बी डिक्लेयर एज ST कम्युनिटी, तो यहाँ पर फर्स्ट ऑफ ऑल एन ऑर्डर विल बी इशूड बाय द ऑनरेबल प्रेसिडेंट ऑफ इंडिया एंड प्रेसिडेंट ऑफ इंडिया विल सेट अप एन इंक्वायरी कमीशन and that then inquiry commission will look into the affair or investigate their affair, their position, their economical position, their historical position, their social position or historical background, all these factors. उसके बाद इंक्वायरी कमीशन अपनी एक रिपोर्ट देता है प्रेसिडेंट को एंड ऑन द बेसिस ऑफ दैट रिपोर्ट वो उसमें रिकमेंडेशन देता है कि वेदर दिस कम्युनिटी शुड बी डिक्लेयर्ड एज SC और ST. और फिर उस कम्युनिटी के और उस कमेटी के और कमीशन के ऑर्डर के आधार पर और रिकमेंडेशन के आधार पर ही प्रेसिडेंट उसको वो करते हैं, डिसाइड करते हैं कि वेदर दिस कम्युनिटी डिजर्व टू गेट द स्टेटस ऑफ SC ST. So now this order has also been challenged in Honorable Supreme Court, and Honorable Supreme Court in today's news itself has held that the High Court does not have power to declare any community as a SC or ST. Rather, this power lies with the President of India, and there is a particular procedure that need to be followed before declaring any community as SC or ST. Now we come to next news. Now Haryana government announces reservation for backward classes in urban local bodies. So basically this is also an important topic. So these urban local bodies means the village panchayat or the municipal corporations. So in our country, there is a distribution of power, and power is found at three levels. One is at the central level, means union government or Bharat Sarkar. Second is the state government, स्टेट लेवल पर होती है, और थर्ड होती है लोकल लेवल पर. लोकल लेवल मीन्स विलेज पंचायत और द म्युनिसिपैलिटीज. Now question arises, if we go to the constitution provisions, there is article 40 in our constitution of India. Article 40 declares that there shall be organization of village panchayat. There shall be organization of village panchayat. So this 40 is the part of DPSP, Directive Principle of State Policy. Now, considering this factor, there were two constitutional amendments in our country. One was 73rd Constitutional Amendment and other was 74th Constitutional Amendment. So, there is a provisions under Part 9 and Part 9A. So, Part 9 deal with the Panchayat and Part 9A deals with the municipality elections. So now Haryana government has provided reservation to OBC. So now question arises whether government or state government has right to provide the reservation. So answer of this question is that yes, state government has the right to provide the reservation in any particular body or local authorities to the resident of that particular area. So generally 33% reservation is provided in the local bodies to the women. So now we come to next. Now we come to this news. SC dismissed plea by the YouTuber for relief. So this also relate to the right of media. So basically we are not concerned with the factual news, rather we are concerned with the constitutional aspect of this news or the legal aspect of this news. So what happened in this case, there is a YouTuber, namely the Manish Kashyap, and he has been booked under various sections of National Security Act, NSA. So what is this National Security Act? National Security Act, NSA. NSA is very draconian law. It means that there is danger from that person to the national security. So what is the allegations against this person? The allegation against this person is that he has given the false information regarding the attack on the various people belonging to the state of Bihar in the Tamil Nadu. So on this information, this news was spread, and this news in some way affected the reputation of the concerned government. This affected the reputation of the concerned government in this way because if the people of particular state are compelled to work in any other state, it means that the economic position of that state is not good, and people are compelled to take the shelter in any other state. So this affected the reputation of the state government or the government of Bihar. So now various cases were registered, or various FIRs were registered against this Manish Kashyap. So now the question arises, the contention on the part of the advocate of Manish Kashyap is that if any person tries to show the good news or the true news on social media, and if you will register FIR against that person under various draconian laws, then it is the violation of their fundamental right, like the right under Article 19(1)(a) of the Constitution of India. So now we'll discuss what do you mean by this right 19(1)(a). So basically 19(1)(a) gives the right to every person, right to speech and expression. So according to Article 19(1)(a), it is the fundamental right of every citizen of India to right to speech and expression. So means that person has the right to express their own views, okay? And state government or even the parliament does not has power to curtail the fundamental right of that person. So now we'll see what will happen. But at present, Honorable Supreme Court has dismissed the plea of YouTuber for relief, means he was not granted bail. Now, India-China strategy needs to be debated. So, in this editorial news, the author is Shashi Tharoor. He is an MP from the Congress party. So now the concern of author in this news is that China is our neighboring country and it has renamed various disputed places. So basically, all of you are aware that there is a dispute between China and India regarding the territory in Arunachal Pradesh. So the concern of China or the contention of China is that some places of the Arunachal Pradesh belong to the territory of China, but the contention of India is that those places belong to India, and even from the historical point of view. So, but now at present, China has renamed various disputed places in the Arunachal Pradesh. Because of renaming, China is also claiming those places. So, as per the information given in this editorial news, we have lost 26 patrolling points in eastern Ladakh out of 65 patrolling points. It means that earlier we were having 65 patrolling points in eastern Ladakh, but right now we have lost 26 out of them. Now, how these have been lost? Because of renaming or because of the construction activities or the any other activities conducted by the China on these posts. So now we are not doing patrolling on these posts. Now, this information has come from a research paper which was published by or which was submitted by a senior police officer. So we can say that this information is also genuine information. So now the question is that what strategy should India adopt in this situation? India को क्या करना चाहिए ऐसी situation में? Now point is that, so as per the author, this is the view of the author, that the government of India is not taking any hard action against the China, but as per the contention of the present government, there is no such claiming of territory by the China. So as per the view of author, we should take strict action against the China. And it is also mentioned in this paper that at the time of Pandit Jawaharlal Nehru, when we gave recognition to China, then we also did not have the good experience with the China. Similarly, at present, our present government is not having, not taking direct action or any, we can say that the strict action against the China. And because of this, China is increasing its access to the Arunachal Pradesh, that is the territory of India. So now, the one of the aspect of author is that at least we should have a debate in parliament regarding issue of China. So as per author, our present government is not taking this issue in the parliament because of fear of losing the general elections. But this is the political that losing the general elections. We will talk on the substantial matter. So as per the contention of this author in this editorial, the government should debate the issue of China in the parliament, and all the political parties and all the respective leaders must give their view. And this view or this present position of China regarding the renaming of various places Arunachal Pradesh, this fact should come to the knowledge of the people of India. Now this news is very important again. The lack of a drug recall law in India. The lack of a drug recall law in India. Now, what is this drug recall? What is this drug recall? ये drug recall क्या होता है? तो basically क्या है? When a drug is manufactured, so there is an expiry date of every drug. तो क्या होता है कि मान लीजिए सपोज एक ड्रग बनी, एक कोई मेडिसिन बनती है और वो मेडिसिन की एक्सपायरी डेट है सपोज दैट 12 मंथ, और वो मेडिसिन अगर 12 मंथ में नहीं कंज्यूम हुई, so after the expiry date it will be useless. But what is happening in India, if this drug has become has expired or it has become useless. Now this drug is again being used in the other states or other parts of the country. For example, the people of India are not so aware in the term of this medical science. So suppose a government officer rejected a drugs in the government laboratory. Government laboratory here means that drugs is not fit as per the given prescriptions or given standard. So now that drug will fail in the sample taken in the government laboratory. So now if the drugs is not consumable, then it should be useless or it will be considered as useless drug. And if the order of one authority that this drug should not be used in UP. For example, officer of UP gives an order that this drug should not be used in UP. So now what is happening? That drugs is being used in Kerala. So this is the concern of the author in this news. Now, so reason being that the people of India are most of the population of India is not so aware about that which drugs whether the expiry date is genuine or not. और एक बात और क्या हो रही है यहाँ पर कि सपोज एक्सपायरी डेट इस ड्रग पर यहाँ पर मेंशन थी एंड नाउ अब वो क्या करते हैं कि उस एक्सपायरी डेट को यहाँ से मिटाकर एक दूसरा लेबल लगा देते हैं. सो अर्लियर सपोज इज यूज्ड टू एक्सपायर ऑन 3 मई 2023, लेकिन उन्होंने लेबल दूसरा लगा दिया, उसमें कहा कि ये 12 दिसंबर 2023 हो गया. So now this practice is also being used. So now question is that if such drugs will be used in country, it will be against the interest of the patient. ये patient के interest के against में है, and we are playing with the life of the patient, although the person or with the life of the person who are consuming such drugs. So now the concern of the author in this news is that in foreign countries like USA, there are strict laws regarding the recalling of drugs. Means if a particular drug has been expired, then उस ड्रग को मार्केट से रिकॉल कर लिया जाता है और उसको डंप कर दिया जाता है कहीं पर. लेकिन हमारे देश में इसके संबंधित कोई लॉ ऐसे नहीं है. रीजन क्या है इसका? रीजन इसका ये है कि दैट फार्मास्यूटिकल कंपनीज are earning a lot of benefits, and these pharmaceutical companies do not want that this drug recall law should be implemented in India. So we are making a attempt to create such law since 1976, but we could not make desired amendment in the Drugs and Cosmetic Act that deals with the various drugs in India. So there is an urgent need to make the law in this point. What are the regulations to curtail misleading food ads? So this is also a very good point. There are so many foods in the market, and when any personality like be an actor, they give the advertisement regarding that food. So they give the misleading advertisement. Means the food they are advertising for may not contain that qualities or may not contain that particular specification. So now this is the concern of this. So now there is an authority which regulate the quality of food, and that is the Food Safety and Standard Authority of India. This is very important. Food Safety and Standard Authority of India, FSSAI. So basically this authority regulate the consumption of food in India, and it also has check over the quality of food in India. Now what are the regulations? There are various regulations to combat misleading advertisement. तो basically generally जो public है वो किसी भी food को judge करती है on the basis of the advertisement. अब advertisement में यहाँ पर रोल आता है Consumer Protection Act का, Consumer Protection Act 1986. So now earlier there was this Consumer Protection Act, but now this Consumer Protection has been amended, and at present we are having Consumer Protection Act 2019. So in this Consumer Protection Act, there is a Central Consumer Protection Authority, CCPA. So what is the functioning of the CCPA? The functioning of the CCPA is that it has control over the disparaging advertisement or false or misleading advertisement. So according to the new Consumer Protection Act, if any person is involved in the misleading advertisement of anything or any product, then that person will be liable to be imprisonment up to 2 years, and that person will also be liable to pay fine that may extend up to 10 lakh rupees. ठीक है, तो अब यहाँ पर यही है कि ये सारी ऑथोरिटीज मीन्स फूड सेफ्टी एंड स्टैंडर्ड अथॉरिटी ऑफ इंडिया and Central Consumer Protection Authority of India, they watch upon the misleading advertisement and any other misleading information which is given by any concerned person. And if any concerned person makes such advertisement, that the person would be liable under the law. So as I discussed with you, High Court does not have power to direct changes to scheduled tribe list. So I discussed this issue with you in the first news, that this is the power of the President of India to decide whether a particular caste belong to ST or community belong to SC or ST, and it is not the right of the High Court. So this view has been given by Honorable Chief Justice of India. So dear students, that's all for today. I will come again with the next topic. Till then, thank you very much. Goodbye.